Hi, I'm Anna Denton-Jones, and in this third week of Knowledge, November 2023, I'm going to focus on teasing out the sort of different legal strands of what claims an employer might face if they have imposed changes that haven't been accepted on employees. The first one we talked about last week is the constructive dismissal, unfair dismissal angle. In addition to that, the employer may find the person stays as an employee, so they don't resign, but they then bring an unlawful deduction from wages claim in respect of the financial loss that they are suffering. Another angle somebody might attack, if they know about this, would be to report the employer to the pensions regulator. Because if there are pensions changes, there are requirements under the Pensions Act of 2004 to consult with members, prospective members and their representatives in relation to a whole list of changes to pensions for a period of 60 days. The pensions regulator has the power to issue enforcement notices around that, and a £50,000 fine could ensue if you have ignored that from the pensions regulator. You could face trade union action if you are unionised. If there's been a collective agreement and the employer has gone against what is in that collective agreement, then you might find a union funding legal action on behalf of their members, possibly even going to court to ask for an injunction to prevent the employer from being able to go ahead with changes in their planned respect. There may be information and consultation agreements in place, slightly different collective agreements, but essentially the employer agreeing with employees that they're going to inform and consult with them about certain things in certain ways. There's a £75,000 fine if we don't follow that. The other angle is around redundancy. If more than 20 people are affected, then under Section 188 of the Trade Union Labour Relations Consolidation Act of 1992, then we are required to consult for a minimum of 30 days. If it's more than 100 people, 45 days over changes before any notices to end employment are given. You might be saying, well, we're not intending to get rid of anybody. This is about changing contracts. The law is pretty clear that because the nuclear option, if you like, will be to bring current contracts to an end and issue new ones. If we cannot reach agreement, then Section 188 applies, and the potential protective award for failure to do that of 90 days pay per employee. Of course, employees with more than 2 years service may be able to claim statutory redundancy payment if they can show that the alternative job that they are offered, the new terms, isn't actually a suitable alternative. It's a demotion, less pay, etc. Then they could be claiming based on their age and their length of service and their week's pay calculation, statutory redundancy pay. Finally, there are requirements on employers to set down certain information in writing to employees from day one now of their employment. Where that changes and is updated, employers have a month to tell employees about those changes. So after we've been through the exercise, we need to make sure we're writing to people the right things. Otherwise, they can bring what we call a piggyback claim. So where they're bringing a claim for something else, like the unlawful deduction from wages, they could add in another couple of £1,000 worth of claim for not doing the right things around paperwork. So all in all, there are lots of reasons for employers to try and chart a sensible route through this whole area. If you have got any questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.